Coming back for some brand new breaking news. MS Now has just learned that FBI Director Kash Patel may be out of a job in the coming months. 3 people with knowledge of the situation say President Trump and his top aides have grown tired of Patel and the unflattering headlines he's been generating recently, including using a government jet to visit his girlfriend and enlisting a SWAT team as her security detail. Joining us, MS Now Justice and Intelligence reporter Ken Delanian and MS Now White House reporter Laura Barone Lopez. Both of them broke this story along with Carol Leonnig. Ken.
Well, Katie, I should say, first of all the qualifiers apply here. With Donald Trump and personnel decisions, you never actually know exactly what's going on. But we are being told that Kash Patel, the FBI director, is on increasingly thin ice. And the president is considering replacing him by the end of the year with Andrew.
Subscribe right now, hit the bell, and leave a like. Because what you are about to hear about what Kash Patel said when he was under oath and what he admitted to the people he was firing before he fired them is more devastating to Donald Trump than anything any political opponent has ever said. Because it comes from the man Trump himself put in charge.
Former Attorney General of Missouri, who is acting now as co-deputy FBI director, along with Dan Bongino. And it's for all the reasons that you just said and others. The use of taxpayer resources, the flying his girlfriend around on the FBI jet, but also the premature tweets, including related to the Charlie Kirk assassination and other investigations, that terrorist attack in Michigan where Patel got out in front of the investigation and tweeted about the arrests before the rest of the government was ready for that to happen.
Let's go. There are many ways a president can be betrayed. Political opponents can expose your weaknesses. Prosecutors can build cases against you. Courts can rule against you. Your allies can abandon you publicly. But none of those cut as deep as this. The deepest cut comes when the man you appointed, the man you defended, the man you pointed to for years as the insider who could confirm your story, the man whose job it was to execute your directives, sits down in a federal grand jury room under oath and gives the prosecution's version of events instead of yours. That is what just happened to Donald Trump with Kash Patel. And the documented legal record of it is more damaging than any accusation from any opponent, precisely because it does not come from an opponent. Stay with me, because I need you to understand 2 separate but connected things that are now simultaneously in the permanent legal record. First, Patel was granted use immunity in the classified documents case. That immunity stripped him of his Fifth Amendment protection and compelled him to testify before a federal grand jury under penalty of perjury. And when he testified, when the choice was between confirming a narrative under oath that might not be true and facing federal perjury charges, his sworn account lined up more with prosecutors than with the standing declassification defense he had been publicly promoting. Second, in the wrongful termination lawsuit filed by former FBI Acting Director Brian Driscoll and 2 other senior officials, Patel's own admissions are now in the official legal record as sworn pleadings. He told the people he was about to fire that the firings were likely illegal. He said the orders came from the White House. He said the criterion for who got fired was prior participation in investigations of Trump. He said the reason was simple. The FBI tried to put the president in jail, and he has not forgotten it. 2 proceedings, 2 records, both describing Kash Patel as the organizational actor, positioned most directly between Donald Trump's instructions and the institutional conduct those instructions produced. And Trump World's response to all of it was to call Patel a snitch. I am going to walk you through exactly why that response tells you everything you need to know about how accurate Patel's account actually is. Let's start with the legal mechanism, because understanding how use immunity works is essential to understanding why Patel's grand jury testimony is so significant. The Fifth Amendment gives every person the right to refuse to answer questions when the answers could be used against them in a criminal prosecution. Witnesses in federal investigations routinely invoke this right, not necessarily because they are guilty, but because the protection exists. Use immunity removes that protection in a targeted way. When prosecutors grant use immunity, they are making a specific agreement. The testimony you provide cannot be used against you personally in any subsequent prosecution. In exchange, you lose the right to invoke the Fifth Amendment on the questions the immunity covers. You must answer. You cannot stay silent. and everything you say is sworn testimony under penalty of perjury. The DOJ did not grant Patel immunity as a favor. They granted it as a prosecutorial weapon, specifically designed to force him into a position where lying to protect Trump carries criminal consequences, federal perjury charges, that no presidential loyalty relationship can protect him from. Before immunity, Patel could take the fifth on every relevant question. He could refuse to say anything that might confirm or deny the defense narrative. He was the perfect loyal witness, useful as a public advocate, untouchable as a legal witness. After immunity, every answer is sworn. Every answer is locked in under penalty of perjury. Every answer that contradicts a previous public statement becomes potential perjury exposure. Patel was the specific individual Trump and his team pointed to as the authoritative insider who could confirm the standing declassification order story. When Trump's allies needed to explain how classified documents ended up at Mar-a-Lago, Patel was the name that appeared, the man who could confirm that Trump had issued a broad standing order that automatically declassified anything he took with him. He was supposed to be the witness who saved the defense. Instead, his sworn account lined up more with prosecutors than with the standing order theory he had been promoting in media interviews. Sensitive records stayed classified. Formal declassification processes were not used. Those two specific findings from his grand jury testimony directly contradict the two central claims of the standing declassification defense. The records were not declassified. The mechanism Trump described was not used. The witness who was supposed to save the defense gave prosecutors the version of events that damages it most. Now, let's talk about why Patel's grand jury testimony is not just an inconvenient witness statement that can be managed through subsequent public advocacy. Before his grand jury appearance, Patel gave media interviews promoting the standing order story. He suggested Trump had legitimate legal authority for the documents he possessed. He was publicly advocating for the defense narrative. And he was doing it without being under oath, without penalty for saying things that might not be accurate, in the specific context of helping Trump manage public opinion about the case. After his grand jury testimony, the situation is permanently different. His sworn account is locked in under penalty of perjury. If he goes back to media interviews and refloats the standing order narrative in ways that contradict what he said under oath, he faces potential perjury exposure. Every future proceeding where the document's case is relevant, any new prosecution after Trump's presidential term ends, any civil proceeding where the document handling is at issue, any congressional oversight process reviewing the grand jury record, that testimony is there. It cannot be walked back. It cannot be revised through a media appearance. It cannot be undone by a presidential pardon. Because immunity grants are made by prosecutors and the testimony once given belongs to the grand jury record regardless of subsequent executive action. The Patel who gave media interviews promoting the defense narrative could adjust his story as the legal landscape shifted. The Patel who testified under immunity cannot. Those words belong to the record now. And the gap between what he said in media interviews when he was free to say anything helpful and what he said under oath when lying carried criminal consequences is the specific gap that tells you everything you need to know about how strong the standing declassification defense actually was. It held up as long as the people who knew the truth were not under oath. The moment one of them was placed under oath and compelled to answer, it stopped holding up. Now let's talk about the wrongful termination lawsuit filed by former FBI Acting Director Brian Driscoll and two other senior officials, because this is where Patel's own words, in the official legal record as sworn pleadings, become the most damaging evidence against the administration. The lawsuit alleges that Driscoll and the other plaintiffs were illegally fired as part of a White House-directed purge targeting anyone connected to criminal investigations of Donald Trump. At least 10 FBI employees were dismissed. Every single one tied to the Mar-a-Lago documents probe or the January 6th investigations. But the most significant element of the lawsuit is not what the plaintiffs allege. It is what Patel admitted to the people he was about to fire before he fired them. He told them the firings were likely illegal, not controversial, not a gray area, not something reasonable people might disagree about. Likely illegal. That is the FBI director's own legal assessment of conduct he was about to execute. From a man who spent years as a federal prosecutor, who understands exactly what unlawful retaliation means in federal employment law. He told them the orders came from the White House and senior DOJ officials. He acknowledged receiving instructions to terminate anyone identified as having participated in a criminal investigation against President Donald J. Trump. He told them the reason. Directly, in words that are now in the legal record, the FBI tried to put the president in jail, and he has not forgotten it. And he told them he only went through with it because his job depended on it, that refusing would have meant his own dismissal. Every one of those admissions is now in the official legal record as sworn pleadings in a federal civil lawsuit, signed by attorneys who face sanctions for knowingly including false material, in a proceeding where Patel can be deposed and cross-examined on every word. The FBI Agents Association condemned the dismissals as unlawful retaliation, endangering the Bureau's mission. The professional inside community of the institution, through which the purge was executed, made its institutional assessment public, and that assessment converges with Patel's own admission from an independent organizational direction. You are halfway through this breakdown. If this is giving you the clearest picture of why Patel in two simultaneous proceedings, grand jury and civil lawsuit, is the most legally damaging development Trump has faced from inside his own team, leave a like right now. 2 seconds. And drop a comment. Do you think Patel understood when he made those pre-firing admissions that they would end up in a federal lawsuit? Tell me below. Here is where the Patel situation becomes most legally dangerous, and where the documented record from both proceedings intersects in ways that create compounding exposure. Patel has now given sworn testimony in 2 separate proceedings, describing conduct that connects him personally to the most legally significant institutional actions taken on Trump's behalf. In the criminal grand jury, sworn testimony about the classified documents case, testimony that, according to legal analysts who have reviewed the immunity grant, lined up more with prosecutors than with the standing declassification defense. In the civil lawsuit, admissions documented as sworn pleadings about the FBI employee purge, testimony establishing that he assessed the firings as likely illegal, received White House direction, applied a criterion based on participation in Trump investigations, and executed the directive under coercion. Any inconsistency between what he told the grand jury and what the civil lawsuit record establishes about his conduct is perjury exposure. Future prosecutors reviewing both records will examine them together. Congressional investigators will use them together. Every accountability proceeding that touches either the documents case or the purge will have access to both. Patel is now the organizational actor most directly on record in 2 permanent proceedings, between Trump's instructions and the institutional conduct those instructions produced. That is the specific form of legal exposure that the loyalty strategy was supposed to prevent. The assumption was that loyal insiders, using the Fifth Amendment, could protect both themselves and the narrative simultaneously, refusing to testify while publicly advocating for Trump's version of events. Use immunity specifically dismantled that strategy. It separated the Fifth Amendment protection from the testimony obligation. And the civil lawsuit admissions added a second record that the immunity-compelled grand jury testimony now sits alongside. The loyalty strategy has a documented vulnerability. Prosecutors know exactly how to exploit it. And the exploitation of it in Patel's case is now in the permanent record for every subsequent loyalist to see. Let me spend time on Trump World's response, because the specific word they deployed reveals more about the accuracy of Patel's account than any legal analysis could. They called him a snitch. Here is why that single word is the most self-defeating response Trump World could have chosen. You do not call someone a snitch for telling lies. If someone fabricates a story about you, you call them a liar. You challenge the accuracy of what they said. You present evidence that their account is false. You call them a fabricator, a partisan operative, a politically motivated attacker. Snitch is a specific word with a specific meaning. Snitch means you told the truth about conduct. The people involved wanted to stay hidden. The word only applies to accurate accounts of real events. You cannot snitch about things that did not happen. Trump World, calling Patel a snitch requires accepting all of the following simultaneously. There was a scheme to snitch about, because you only snitch about schemes that exist. His account of the scheme is accurate enough to have caused real damage, because snitching means telling the truth, and the participants wanted the scheme kept secret. which is what makes telling the truth snitching rather than just reporting. By calling Patel a snitch, Trump World has implicitly confirmed that the likely illegal admission is true, that the White House-directed framing is true, that the terminate anyone who investigated Trump criterion is true, that the motive, the FBI tried to put the president in jail, and he has not forgotten, is true. The defensive response designed to discredit Patel is the specific response that most directly validates everything he said. That self-defeating quality tells you something important. The people deploying this response do not have a factual rebuttal to Patel's admissions. If they had evidence that his account was false, they would present it. The snitch label is what you reach for when the account is accurate and you have nothing else. He said the firings were likely illegal. He said the White House ordered it. They called him a snitch. That single word tells you everything you need to know about what his admissions actually revealed. Let me close with what the Patel situation means for everyone else still in Trump's orbit, because the documented exposure in 2 simultaneous proceedings is a signal that every remaining loyalist needs to understand. Patel did not walk into a grand jury room and voluntarily decide to cooperate. He was compelled, stripped of his Fifth Amendment protection by an immunity grant that gave him no choice but to answer truthfully or face perjury charges. The loyalty was tested not by a moment of personal choice, but by a federal legal mechanism specifically designed to separate personal loyalty from sworn testimony obligations. And the result, testimony that in the grand jury lined up with prosecutors and admissions in the civil lawsuit that are now in the permanent record, is not evidence that Patel betrayed Trump in any morally simple sense. It is evidence that when the legal mechanism forces the choice between confirming a story under oath that may not be true and facing federal perjury charges, the loyalty calculus changes. Every Trump loyalist who has been publicly advocating for a specific version of events that serves Trump's legal defense is a potential target for the same prosecutorial tool. Use immunity is not exotic or rare. It is a standard federal mechanism available in every investigation. Its application to the most publicly prominent Trump narrative advocate on the documents case demonstrates that the loyalty-based defense strategy has a specific and well-documented vulnerability: the next immunity grant, the next loyalist placed under oath, the next grand jury appearance that forces the same choice between confirming a narrative and facing perjury charges. Each one tests the same vulnerability the Patel situation has now publicly exposed. Trump was stabbed in the back by the man he appointed to protect him, not out of personal betrayal, out of the specific legal mechanism prosecutors designed to make personal loyalty and sworn testimony obligations incompatible. The testimony belongs to the record now, both of them. And the snitch label Trump World deployed in response belongs to the record too, as the most revealing thing they could have said about whether Patel's account is accurate.